everybody. I'm back again with a little bit more about wills and trusts and hopefully answering some of your questions that you all have had for a long period of time. So, today we're going to talk about trust and how they fail. So, a lot of times people create trusts, and many times the trust that I get when I see them after the person who created the trust passes away, I have to bear the bad news to tell the person who did that, who the surviving spouse or the child, that this trust is not going to avoid probate, that they still need to get that will and they still need to go to court and there's still going to be probate. And the biggest reason for that is that the trust was created, but nothing was put into it. So when you create a trust, you create a box, let's say, a box. It's not legally correct because a trust really is an agreement between the person who makes the trust, the grantor or settlor is what they're called, and the trustee, the person who holds the trust, and for the beneficiaries, which are the other people that are ultimately going to get the assets in the trust. The agreement doesn't really have a form or a structure, but in general, practically speaking, a trust is a box. And you consider that as a gift, a present, right? A big box with a bow on it. Now imagine you gave that big box with a beautiful wrapping, a bow on it, and when your child opens it, there is nothing in it. That's pretty much what you've done when you do a trust and you don't fund it. You've given them an empty box as a present. Not a good thing to do, right? Nobody wants to do that. And the way that we prevent that from happening is by knowing right from the beginning when we create the trust that we are responsible for funding it. And the way we fund it, there's several different ways of funding it. When they say trust funding, that sounds really complicated, right? And in some ways it may be complicated depending on the kind of assets you have. But it is fairly simple in one way, and that is that the trust will either own the assets you have that you want to distribute or will be the beneficiary of the assets you have that you want distributed. So either the trust is going to get the assets after a person dies as the beneficiary, or the trust is going to own it from the very beginning. Some of the examples of what the trust can own from the very beginning is, let's say, your primary residence. Your house will go into the trust will own it, and the house will be titled under the trust. The advantage of that is that if you have children who are minor, then the trust is holding it, the house, and your children who cannot inherit anything because they're minor, and please do remember that minor children can inherit nothing directly. Nothing from life insurance, not your house, not your accounts, not your 401ks, not your IRAs, not your rental properties, no matter where your assets are, even 529s, they cannot inherit them directly if they are minor, under the age of 18. A trust keeps all these assets in one place with a trustee to make sure these assets are distributed the right way to give and provide for your child until your child is a certain age. Based on the design of the trust, your child can either get it at a certain time or age in different stages, or they can actually have it as a lifetime asset protection. And that depends on what you would like to do for your child and how you'd like to design the trust. But in any case, if you don't put anything in that trust, like I said, then you're not giving your child anything, an empty box. Or even your spouse, for that matter, whoever your loved one is that's going to get that box after you. So, like I said, either the trust holds an asset, for example, the house, or you can have the trust be the beneficiary after you pass, which would be like a life insurance, let's say. And instead of the beneficiary being your wife or your child, you have the trust be the beneficiary. So you can have that as your beneficiary so that your trust gets that asset right after you pass so that the box is filled at that point in time. Either ways, if you do not do that, if you don't have the trust as a beneficiary or you don't have the trust as the owner, the trust remains empty and it's an empty box, which means that you have not created a trust that will work. It will fail, and that person is going to go through probate. So make sure when you create your trust that you figure out how to fund it and keep it funded. Anytime you buy a new asset, it needs to go into the trust as well. Anytime you sell something and you buy something new, you need to make sure that the retitling is done the right way. Well, that's all I have for you today, and I'll talk to you later soon. Have a great day, and don't forget to subscribe. And if you have any questions, then you can book a call right at my website, notanilaw.com.